Trudy, if you're trying to say something, you need to unmute it. Okay, I'll be over in just a second, all right?
Good afternoon. Is there anyone available from the county?
Good morning. This is Julia Decker, Planning Manager. We are in the process of getting the Ms. Phillips situated with the computer over in another part of the building. So she should be ready in just a moment or two. Ms. Mendoza will be right back.
Okay, are we doing, is that the first hearing?
Yes, ma'am.
Okay, I wasn't sure the Phillips hearing. Okay, let me know when you're ready. I'll just be here on hold.
Thank you.
Yeah, it's not me. Okay.
Okay, Ms. Mendoza is here. I believe we're ready.
Okay, great. Well, I did see that the recording is going, so I'll go ahead and open this hearing. My name is Laura Westmeyer. I am the hearings officer for Clatsop County for this matter. This is file number, well, I have a violation number. Is that the same file number, Ms. Mendoza, that the county uses?
It is.
Okay, so this is for case number 20-000823. In regard to what the county has alleged as two violations of the Clatsop County Code and the Clatsop County Land and Water Development Use Code. The first one is in regard to a public nuisance for accumulation of solid waste. The second is an unpermitted development auto wrecking yard. The property that we're talking about for this matter is located at 38212 Highway 26 in Seaside, Oregon. And the county has issued this notice of violation to Trudy Phillips. And I understand that Trudy Phillips is on is appearing at the hearing virtually along with the rest of us. Ms. Phillips, are you represented by any legal counsel?
No, I'm not.
Okay. So I'm going to just go ahead and go over the procedure for this hearing before we begin. As you can see, this is a virtual hearing. We're going to conduct it with all of the procedures that we would is as if we were in the same hearings room. I will say that if we experience any technical difficulties or anyone gets disconnected for any reason, including myself, the hearing will automatically pause until we can rejoin. In terms of the order of events, the county will go first. The county will present all of its evidence and arguments that it has to present. And the county has the burden of proving that each of these 2 violations that it has cited exist. Ms. Phillips, as the respondent for this matter, you will have an opportunity, if you would like, to ask the questions of the county and to cross-examine any of the county's witnesses. Once the county has finished its case, then you, Ms. Phillips, will have an opportunity to present all of your evidence, arguments, and defenses that you wish to assert today, including calling any witnesses that you would wish to call today in your defense. This is the opportunity to present anything that you have in regard to this citation, and you may be precluded from raising any issue in a later appeal if you don't bring it up now. This is a de novo hearing, meaning that I'm going to take in all of the evidence and arguments and facts that you are presenting to me from both the party and the respondent, and I will issue an opinion based on those facts. My only job here is to determine whether these violations that the county cited exist. If they do exist, I will have to issue a civil penalty, and the county has recommended a civil penalty in the notice of violation. And before the end of this hearing, I'll ask both parties to speak to that recommendation in the event that the violations are found. I am a neutral third-party decision maker for this matter. I'm not an employee of the county. I don't represent the county. I am here to be the third-party decider of this citation. With that, I've had no ex parte contacts, no conflicts of interest, and I have no bias or prejudice to report that would affect my ability to conduct this hearing. Does anyone wish to challenge my ability to conduct the hearing? Okay, I hear none. So again, this is a virtual hearing that is being recorded. For the record, if you are going to speak, if you would please first state your full name and spell your full name for the record so that we have it on the audio before you begin your testimony, that would be helpful. And for anyone who believes that they may speak today to testify, please go ahead and raise your right hand.
Does that include me?
It does.
Do you solemnly swear or affirm on the penalty of perjury that the testimony you're about to provide in this hearing is the whole truth and nothing but the truth?
Yes.
I do.
Okay. Thank you.
Did it not talk? I have to hit mute.
No, you're live.
I'm live?
You are.
Okay. Yeah, I do.
Okay, great. And so with that, we'll begin with the county, who looks like it's being represented by Ms. Mendoza today. Go ahead, Ms. Mendoza.
Thank you. My name is Nancy Mendoza, Nancymendoza. Okay, on November 21st, 2014, staff received a complaint from Clatsop County Animal Control describing the condition of the property, which included abandoned vehicles and an accumulation of solid waste. A notice of warning was issued, certified mail for the following violations: unpermitted development, 2 or more inoperable vehicles, and public nuisance, accumulation of solid waste. The notice of warning was returned unclaimed. On December 10th, 2015, a notice of violation was mailed certified mail for the following violations: unpermitted development, 2 or more inoperable vehicles, public nuisance, accumulation of solid waste, dangerous building structures, dangerous to health or safety, and attractive nuisance, attractions that may prove detrimental to children. The notice of violation was returned unclaimed. On May 6, 2021, an incident report was emailed from the Sheriff's Office to Code Compliance describing the condition of the property, including accumulation of solid waste, inoperable vehicles, and a lack of sanitation facilities on the property. On February 16th, 2022, site visits, photos shown accumulation of solid waste and inoperable vehicles. And those photos, there were photos from January 12th of 2022 to determine the status of the violations that were stated in the February 17th notice of infraction. That was mailed both regular and certified, as well as being posted on the property. And those were for the following violations: auto wrecking yard, accumulation of solid waste, and no sanitation facilities, and a dangerous building. The certified letter was signed for. On December 21st, 2022, at a site visit, the property owner claimed the sheriff told her to move the vehicles onto ODOT property so that they could be towed. Staff verified with the sheriff that that was not what she was instructed to do. Staff also contacted the Oregon Department of Transportation, who verified they did in fact tow the vehicles, and that OSP did not cite the property owner for dumping vehicles on state property. The photos from a site visit on May 11th show an auto wrecking yard with a truck license OR 595 LDE surrounded by solid waste with a flat tire, and another truck further back on the property covered with stovepipes and other unidentifiable material. The photos also show an accumulation of solid waste with tires, household garbage, abandoned RVs, and household items littered on the ground. A notice of warning was mailed on May 11th, both certified and regular mail, for the following violations: public nuisance, accumulation of solid waste, and unpermitted development, and auto wrecking yard. The certified letter was returned unclaimed. Site visits on June 8th and 12th showed some progress being made at the front of the property, but there was still a significant amount of waste and vehicles on the property beyond the no trespassing signs. On July 7th, 2023, a notice of violation was mailed, both certified and regular mail. It was also posted on the property for the following violations: public nuisance, accumulation of solid waste, unpermitted development, auto wrecking yard. The certified letter was signed for. On September 12th, 2023, photos from a site visit show the same two vehicles, the same two inoperable vehicles from May 11th, 2023, in the same state as from May 11th. A site visit on October 12th, 2023, the photos show the same inoperable vehicles from September and May in the same state, and an accumulation of solid waste. After the site visit on October 12th, 2023, an administrative review was completed with the following violations still present on the property: public nuisance, accumulation of solid waste, Clatsop County Code, Chapter 8.04, nuisance abatement, and unpermitted development, auto wrecking yard, land and water development and use code, Article 1, introductory provisions, Section 1.0500. On October 13th, a notice of hearing was mailed, both certified and regular mail, for the violations listed in the administrative review. A notice of hearing was also posted on the property on October 25th, 2023. And as of today, the certified letter has not been delivered. And that is all I have.
Okay, thank you. Ms. Phillips, do you have any questions for Ms. Mendoza?
You can talk.
Oh,
You're
I
live.
can talk,
You're
okay.
live.
Well,
So now is just your opportunity to ask any questions that you have of the testimony that you just heard. You will later have an opportunity to present your case.
well, first of all, the tires and a lot of other things that are on my property are tires that people, I'm sorry about my talking. I have Bell's palsy. Anyway, I'm sorry if you can't understand it. Anyway, but
I can understand
all
you.
okay, thank you. That is stuff that over all the 38 years that I have lived there, has been left in the pullover in front of my property. Nobody will come pick them up. I have called everybody. They're not mine. They never were mine. But if if nobody picks them up, I just set them in a stack. I got like 4 stacks of them, and there's still another big truck tire, a big truck tire. You know, like the what do they call the ones that are the 18 wheelers, and that's also there too. And it's still out front. I have not moved it to the back of my property, and it's been there like 3 or 4 years, and still nobody ever picks it up.
I'm just
So-
gonna pause you for 1 minute, Ms. Phillips. Do you have any questions for the county?
Well, I'm just yeah, the count. Okay, the sign out there that says no dumping, I wrote letters and made phone calls for about 15 years before I got a sign put up there that says uh, littering, you get a fine. About 2 years ago, they put a new one up there. Okay, I have since 1985 is when I bought that property, and I've been cleaning that up front since then. I bought $3,000 worth of dirt and rock and made a berm because everybody, tourists, locals, everybody pulls over there and they go and they poop and they pee. And they take their dogs out and all their dogs poop and pee. And I have been dealing with that all along as well. And nobody would put up bathrooms. Nobody would put up a garbage recycle thing for all the people that pull over there. There's a historical sign there too. And they were nice enough to come and ask me if they could put it there. And I said, oh, of course. Okay. So, but like the stovepipes, that was artistic in my mind.
Okay, I'm
Anyway.
gonna pause you just again. Do you have any questions for the county?
Well, I'm telling, I mean, what this is, her interpretation and my interpretation are a little different.
Mhm.
It's not auto wrecking yard. Over the years, different people have said, can I leave my car here just for a week or two? And they're going to go do something. They never come back. And I don't have a title, so the towing company won't take them. I don't have keys because they were going to come back supposedly and pick them up. I did finally,
Ms. Phillips, just procedurally, I want to make sure the county is finished with its case before you begin yours. So,
Oh,
Ms. Mendoza, does the
okay.
county have further witnesses?
No,
Okay, and you're okay to stand by in case there are questions for you?
absolutely.
Okay, go ahead, Ms. Phillips, with your testimony.
Okay, where will you want me to go back where I was at? I don't. It was never on auto wrecking yard is where I was at, right? And it's just people at different times. I have a hard problem saying no to people. Okay, I've had that problem for a long time, and so if somebody comes and they say, "Oh, I gotta go do this," or "I'm going to Alaska to work," or something like that, and then I never hear from them ever again, and I've got this vehicle with no paperwork or no keys or nothing, so it just sits there and sits there. And to get rid of it is like seriously almost impossible. Um, and the ones that I have gotten rid of, um, I I paid dearly to get rid of them. I had to pay the tow truck driver to haul them away, and I went to even motor vehicles. And this is early 2000s. Even I was getting rid of vehicles. Um, I mean, I did finally quit about 2015 when so from 2013, I had a stroke and I rehabilitated for about 6 months. And when I passed the 8th grade test, I quit rehabilitation because I was pretty smart when I was an 8th grader. Anyway, but the, my house has been robbed. All the records are in the Multnomah County. I mean, small, no, I don't know why I said that, in the County police sheriff's records of the horrible burglaries. They finally incarcerated one of the guys who was tried, and for some reason they never put him in jail, but he was ordered to pay through court $32,000 to me because that was just the stuff I could prove that he stole, like stuff I had pictures of, and I had oh shoot, what's it called when people come and assess your stuff? Um,
Appraised.
anyway, I had pictures and the value of them that I just got ordered to be reimbursed for that. And they just arrested him. This happened in 2005 or 9. I can't remember, but it's in the public records at the sheriff's office. And I finally just now, I'm getting $7 a month in restitution from him till he gets out of jail again. Anyway, his name is Timothy LeCarry. And so then, and I have been robbed multiple times to the point where I don't even call anymore because they never do anything about it. The sheriffs don't. Anyway, but the 2015, the people that live in the Scooter's house restaurant that just burnt down, three of them were they're felons. They like 7 years in prison and stuff like that. And the sheriffs took their testimony saying that I had C4, which is an explosive, on my property. And they never talked to me. They never, ever talked to me. I was at work. I work all the time. And they came to my property, 15 different vehicles, police vehicles, ATF, FBI, sheriff, state, county. I'm leaving somebody out, but anyway, there's somebody else there too. And they sliced my mattresses in my house open. They tore doors off. They destroyed everything. And when they didn't find anything, mind you, they could have just asked me. They just left everything like it was. And that was in 2015. And I went and talked to Tom Bergen for about a half hour because he knew me and he knows better, or he knew better. I don't know. But anyway, they never cleaned up nothing. They never said, I'm sorry. They never, nothing. I'm sorry, I'm getting emotional. I clean it.
It's okay, Ms. Phillips, you can feel free to take your time and take a minute. I'm just gonna talk about the process and what we're here to, what this hearing is for. So this hearing is only in relation to the accumulation of solid waste and auto wrecking yard that you heard the county testify to earlier. So if you do have a challenge or you disagree with the county's assessment, you disagree that there's solid waste on your property or there's an auto wrecking yard on your property, now is your time to talk about that.
Okay, if I disagree that it's there, no, I don't disagree that it's there. I disagree with the fact that nobody would ever help me move anything. That if stuff is abandoned, the county never. I believe me, I have called many times. Never offered me any solution. How do I get rid of other people's stuff, whether it's left in the driveway or left on the the right of way that I own it. I paid taxes on it, but the state has the right of way, or county, whoever it is. anyway, and there's been stuff out there for, I mean, even people who fixed the road left piles of asphalt right there on my property, and which hardens, and you can't get rid of it ever. Okay, I'm even the guys that are putting in that right now, they're putting in a thing for cable or something like that, internet, whatever it is. But they walk over there and pee and poop. They don't have any facilities while they're working out there, so they just walk over there and pee and poop, and then they leave their piles of toilet paper and whatnot. No, God, it's just been ongoing, and I didn't know that when I bought it, that I was going to have such trouble with the highway and people. And but yeah, I want to get rid of the cars. I try to get rid of the cars, and you know, in one of those pieces of paper here, it said that Matt Phillips said I didn't do what he told me to do, and that is a lie, which really pissed me off because I've known Matt Phillips since I was working at the Ecola State Park as a ranger, and so I don't know why he would say that, but he told me to type out my notice that the vehicles would be removed and put them underneath, and I did. I did it on every single vehicle that was there, and I could only afford to move so many, and I got rid of 3 or 4 of them, and they're still there, and you can go look at the notices are still underneath every windshield wiper that I put them on. But even though I work all the time, I do run out of money, and like I said, I have gotten rid of a few of them, but it costs money to remove them. There's like 1, 2, 3, 4 left that I haven't got removed yet. But it's like $185 every time somebody comes to remove them. And they will get removed. It's just as I can afford it.
Thank you, Ms. Phillips, for your testimony. So what I'm hearing is the county has submitted its case with these 2 violation allegations and has presented evidence showing solid waste and automobiles on the property. Ms. Phillips, you are admitting that the violations exist, is my understanding, and you're working on getting them resolved, but you're having
I work every day. I took last week I took 1 load to the dump, and yesterday I took another load to the dump.
Thank you for that. So at this time, I'd like the parties to speak to any sentencing recommendation, beginning with the county, and perhaps any proposal for abatement or any assistance with abatement or a process that you might offer if you have that. Go ahead, Ms. Mendoza.
Thank you, Your Honor. The county recommends that the fine of $500 for the auto wrecking yard be due immediately, and the fine of $500 for the accumulation of solid waste be paid immediately. The county also recommends that the property owner be given 180 days to abate the violations on the property. Those violations are not abated within 6 months, that the remaining fine of $19,500 for the accumulation of solid waste and the remaining $19,500 for the auto wrecking yard be recorded as a lien with the county clerk. The county can offer the property owner a voucher that will provide a voucher where she can take the solid waste to the local transfer station to get rid of some of the solid waste. if the property owner is willing, the county can help to locate resources to remove these the solid waste and automobiles, but that's no guarantee that it'll be done. But the county is more than willing to help her locate more resources.
Thank you, Ms. Phillips. You heard the county's recommendation. Do you have any statement or closing statement to add?
Well, yeah, I'm gonna need like more time because when it rains, my place gets muddy if we walk around in it. And I've already had enough injuries and spent enough time in the hospital. I don't need to do hurt myself again. I can't afford labor. So I pretty much have my son came up from Oklahoma this summer, but only for 2 weeks. You know, he works, he's a paramedic. And so that's about it. And, you know, you have to pay people to help you. People don't do it for free. And I just, when I have money, I this last week, I hired one of the guys that lives in Jewel to come out and help me. He helped me haul 2 loads in. And, you know, and then we had solid rain, or we probably could have gotten 3. But
Okay,
it's
Ms. Phillips, the county,
if I could have an extension to get it done, I know it's slow because money just allows so much.
what is the date, Ms. Phillips, that you believe you would be able to abate the violations?
Well, I don't want to give a date right now because it's winter and everybody's saying we're going to have a horrible winter.
So the
So
county
it's
has
gonna be
offered 6 months, 180 days. That would take us
okay.
to
How
May.
would that? What would that give me some sunshine? Spring, 6 months is December, January, February, March, April, May. If I could have till the end of July, I think I could get it done because my son's gonna come back again in July. That's when he came this year. That's when he gets his vacation.
Ms. Mendoza, so that's 8 months instead of 6 months. Is that acceptable to the county?
It is.
Okay. Okay, anything further from the parties?
Nothing from the county.
Ms. Phillips, anything further?
Um, just I'm doing as much as I can. You know, like I had COVID and I had long haulers COVID, and then I got the Bell's palsy. And it's been one thing after another, and all the burglaries and whatnot.
Thank you for your statements and your testimony today. This hearing, we're wrapping up this hearing. We have one other hearing. I think I'll stay on for because it's at the same time. Is that correct? Somebody from the
Yes.
okay. In terms of next steps for this hearing, I'm going to issue a written decision that will be finding that these violations occurred and with the recommended penalty that the parties have agreed to today. So you can expect to see that in the mail. And this hearing is now adjourned. Thank you.
Thank you.
Okay.
Thank you.
Go
We'll just
ahead
take
and-
1 minute or two to transition here and come back together. Mr. Ledgerwood, are we waiting for anyone from the county or the respondent side?
All parties from the county are present. I do have an email with the responsible. He's not in Astoria. So I've sent him the Zoom link again. Hopefully he can join. I'm not sure how long we should give him. I did talk to our planning manager, Julia Decker, who's on the call, and we kind of agreed that we should just move forward today. If that's agreeable to you.
Okay, did I get an email from the respondent?
No, I can,
Just a text, okay.
I can forward it to you if you want.
That's not necessary. I'm just wondering if are they planning on coming today?
I don't know.
You don't know. Okay, that's
I
fine.
don't
Then
know.
we'll move forward. Because this hearing was noticed for 10 o'clock, correct? Okay,
Correct.
it's now 10:38, so we'll go ahead and open this hearing. This is the recording is still going. This is for file number 23-000282. Again, I'm Laura Westmeyer for the record, Clatsop County Hearings Officer for this matter. And this case concerns a violation alleged by the county of the Clatsop County Land and Water Development Use Code regarding an unpermitted short-term rental at 32379 Ivy Lou Acres Lane in Warrington, Oregon. This notice of violation was issued to Nathan and Jason Dean, who are not present in the hearing today. The county is present and represented by Mr. Rod Ledgerwood. I'll go ahead and skip over the procedures unless the county would like me to go over those. Okay, so just required disclosures. I have had no ex parte contacts, no conflicts of interest, and have no bias or prejudice to report that would affect my ability to conduct this hearing. Does the county wish to challenge my ability to conduct the hearing? Okay, hearing no objection, I'll go ahead and ask anybody who's going to testify to raise their right hand. Do you solemnly swear or affirm on the penalty of perjury that the testimony you're about to provide in this hearing is the whole truth and nothing but the truth?
Yes.
Yes.
Okay, county has answered affirmatively. I'll just remind you that even though the respondent is not present in the hearing, and I haven't received any evidence or arguments from the respondent in relation to this matter, the county still does have the burden of proving that this violation exists. With that, you can go ahead, Mr. Ledgerwood.
Thank you. The county identified the unpermitted short-term rental on June 12th, 2023. Document numbers 2, 3, and 4 kind of detail that discovery and the advertisement that was found on a advertising website. Staff issued a notice of warning on June 15th. The U.S. Postal Service has lost that. We've submitted a claim and it's been unfound. Staff then contacted the responsible party, Nathan Dean, via phone, and then subsequently again by email on July 24th. Document number 6 shows that email dialogue. In those discussions, county outlined the requirements for short-term rental to be permitted in the RA5 zone. Further, LAWDUC section 2.01 requires any development to have a short-term rental permit. And in LAWDUC section 4.2720, short-term rental is listed as a type 1 development for the RA5 zone. I do want to pause, Your Honor, and it does look like someone has joined. Nathan Dean may have just joined. I don't know procedurally if we should continue or.
If you can unmute, Mr. Dean, if you are on the.
Did I do it?
I can hear you.
Okay.
You're here to appear at the hearing?
Yes.
Okay, then we will pause. Thank you, Mr. Ledgerwood. So this hearing was set for 10 o'clock this morning. We did open it a few minutes ago. I am going to go ahead and go and take a step back and go over the procedure for the hearing since the respondent is now on the call. So procedurally, the county has the burden of proof of proving by a preponderance of evidence that the violation that it has cited in this notice of violation exists. That notice was written for a violation of a short-term rental unpermitted development under the Clatsop County Code or Clatsop County Land and Water Development Use Ordinance, concerning the property at 32379 Ivy Lou Acres Lane in Warrington, Oregon. Violation was issued to Nathan and Jason Dean. And it looks like Nathan Dean is now on the call. So procedurally, the county goes first and presents all of its evidence and arguments that it has to present in relation to the violation it's alleging. As the respondent, Mr. Dean, you have an opportunity to question or cross-examine any of the county's witnesses if you choose to do so. Once the county is done with its case in chief, then you, as the respondent, will have an opportunity, if you choose, to testify and submit any evidence and arguments that you have, including any defenses that you wish to assert in relation to this alleged violation. If you don't present everything that you have now, you may be precluded from doing so in a later appeal. So now is your time to present all of those evidence, arguments, and defenses that you might have. If you do testify, then the county will also have an opportunity to cross-examine you or to ask you questions about your testimony. And I will, before the end of the hearing, ask that the parties speak to a sentencing recommendation in the event that a violation is found. My only job here as a neutral third-party hearings officer is to take the facts and all the arguments that you present to me, look at the code, and see if the violation exists. So I will make a finding after the close of the hearing as to whether this short-term rental unpermitted development is a violation or is not a violation. And if I do find a violation, I will issue a civil penalty, which is why I take statements from both parties as to that civil penalty before the close of the hearing. I'll go ahead and say again, for the record and for the benefit of Mr. Dean, that I, again, am a third-party hearings officer. I'm not employed by the county. I'm not an agent of the county in any way. I'm here to decide this matter with the county as one party. So I have had no ex parte contacts, no conflicts of interest, no bias or prejudice to report that would affect my ability to conduct the hearing. Mr. Dean, do you wish to challenge my ability to conduct the hearing?
No.
Okay, if you will testify or believe you may testify today, I do need to swear you in, so please go ahead and raise your right hand and answer affirmatively if you agree that the testimony you're about to provide in this hearing is the whole truth and nothing but the truth.
That's the whole truth and nothing but the truth.
Okay, so we will again take a step back. Mr. Dean, you were provided with the notice of violation and the case file in coming to this hearing, correct?
I believe so. It was probably an email that I got. I didn't see that it was today until I just got an email this morning. So
Okay.
now that I'm in it.
Okay, so Mr. Ledgerwood is speaking on behalf of the county and presenting the county's case at this time. If you wouldn't mind, Mr. Ledgerwood, starting over. And we'll go from here. Thank you.
The county staff identified the short-term rental on June 12th, 2023. Document numbers 2, 3, and 4 kind of outline that discovery and the advertisement that was found. Staff issued a notice of warning shortly after on June 15th, 2023. That was lost. A certified letter was lost by the U.S. Postal Service and it remains unfound after claims were submitted. Following that, staff contacted Nathan Dean via phone and then a subsequent email outlining that conversation and any requirements. Document number 6 is that email exchange where permit or code requirements are outlined and permits are required for a short-term rental. LOTUC section 2.01 requires a development permit be issued for permitted developments or uses. The property is zoned RA5, and LOTUC section 4.2720 includes a short-term rental as a type 1 use, and subject to the standards of Clatsop County Code 5.12. Staff and the responsible party exchanged more emails in August. Document number 8 shows that exchange, where the responsible is attempting to get a permit application signed by all owners. Rental activity was found to have continued during this time period. A short-term rental permit application has not been received by the county to date. A notice of violation was then issued September 12th, 2023, imposing a civil penalty, and provided 30 days to correct that. The responsible party uses a property management company or rental management company to manage the rentals. That company has submitted transient tax returns indicating that rents have occurred starting in about April 2023 to present. We checked this morning, and the short-term rental advertisement is still live on Airbnb with reviews from July and August. That is, I think, all that I have.
Thank you, Mr. Ledgerwood. Mr. Dean, do you have questions for Mr. Ledgerwood?
No questions.
Okay, Mr. Ledgerwood, does the county have any further witnesses? Okay,
No, we
Mr.
don't.
Dean, now is your opportunity to testify and present any witnesses, evidence, and arguments that you have.
Okay. Yeah, so initially we were under the impression that our third party, the rental agency, was supposed to take care of all this. Once we found out that they didn't, but right now I've got all the paperwork filled out, except for the only thing I'm missing is the other owner, which is my brother, which is hard to track down, in a sense. So I'm working on trying to get a inked signature from him, unless I can sign it and put it in without his signature. I guess that would be my one question for him, I guess. But our intent is to do any kind of back tax or whatever owes for that property, since the third party rental agency didn't get all that done when we first initiated it.
Okay, thank you, Mr. Dean. So what I'm hearing is you are not disputing the existence of the violation, although you believe that it was being taken care of. So you're not disputing the existence of the violation. Is that accurate?
Yes. Once we found out that they hadn't done it, then we were told that, oh, this paperwork had to be filed because it was in violation. So
Yeah.
been trying to get that taken care of here now for the last couple months. And really the only thing I'm missing is a wet ink signature to get that done.
Okay, and I assume you're talking about an application for a development permit from the county.
Yes, the form that I had gotten online from the county.
Okay.
That required 2 signatures, one from each owner, myself, and then my brother.
Mm-hmm. Mr. Ledgerwood, do you have a response for that? The question about the signatures on the application?
I do. I believe that the county does accept digital signatures. And so if you're able to contact your brother Jason, or if you're able to contact Jason and get a digital signature, I believe the county does accept those, if that makes the process easier.
It might. He doesn't really have a computer. I don't know if he can sign up via his phone. I'm not really sure if it's a PDF where I add the digital signature myself, or if the county has like digital copies that already have a inked signature block. I mean, I can look into the digitized process of that, but it might make it easier only because I do have email traffic back and forth to him, but not usually any kind of talking. I haven't actually spoken to him. I'm going on about a year now.
I see. No further questions.
Okay. I would like the parties to, since you are stipulating to the existence of the violation, to speak to the sentencing recommendation, starting with the county.
Thank you. I would recommend that the $500 civil penalty be paid do immediately. And we're willing to provide up to 60 days for a complete application to be submitted. And until then, we would request that no rental activity occur. This is due to any life safety issues that may be present at the uninspected property for any prospective tenants.
Thank you, Mr. Dean. Do you have any comment or statement on that sentencing recommendation that you just heard from the county?
No, I guess, well, is that able to pay online or something? I only ask because I'm not in the area.
Yeah, payment can be made via cash or check, or we can take phone payments over the phone. And there's any card payment that's made to the county, there's a small fee that's applied to the credit card processing company. So we can take phone payments.
Oh, okay. Is that something I should get online at a different time, or is that like a phone number I can get from you now?
You can call our office. I can give you that
Okay.
phone number when you're ready.
Yeah. Okay, I am ready.
503-325-8611. That will call the land use planning office, and you can speak with staff and make payment over the phone. We can
Okay.
provide receipt via email.
Is that the same with once I can get all the required paperwork signed and sent in, can I use that same phone number to pay the $500 fee for the application?
That is a different department. Our tax
Okay.
office is the one that administers that. I can give you that phone number when you're ready.
I am ready.
503-325-8522.
Okay.
And Mr. Ledgerwood, who should Mr. Dean speak to in regard to the signature and application for the development permit? Any questions about that process?
Julia Decker, if you could speak to this digital signatures. I do have a response from Assessment and Tax, and they do take digital signatures. You can speak to Julia Myers. She is the primary short-term rental person there. Julia Decker.
For the record, I'm Julia Decker, Planning Manager, Clatsop County, JuliaDecker. And yes, the county will accept digital signatures.
Are the forms already set up to have digital signatures on them, or is that something I have to figure out with Adobe or something?
These are assessment and taxation forms rather than planning forms. I believe that they are not set up for autofill or something like that.
Oh, okay.
So I would have you contact assessment and taxation and Julia Myers. And that telephone number is 503-325-8522. I would have you contact Julia Myers about how they might set up something for digital signatures, but they do accept them.
Okay, cool. That might make my life a lot easier.
Anything further from the parties?
Nothing from me.
Not from the county.
Okay. Thank you all for your time and your testimony. As stipulated by the parties, I am going to find that this violation occurred and issue the presumptive fine of $500. So that will be in writing to you at the close of this hearing. And with that, we are now adjourned. There's no further hearings today, so I'm going to get off the Zoom. Thank you all for your time.
Cool. Thanks a lot.